Hello and welcome to PGurus channel. I'm your host Sri Iyer. Today I have two special dignitaries who are gracing our channel. So before I go in on our topic, which is a very important one, I'd like to introduce our guest for today, Sri N Venkataraman. He is the additional Solicitor General of Government of India, and Sri Sridhar Chityala. He's a banker, he is a venture capitalist and an author. Venkataraman ji, Sridhar ji, welcome to PGurus channel.
Thank you so much, Ayerji, for giving, for inviting us to be here.
Thank you, Sridhar.
Thank you so much. So, viewers, this is going to be a slightly different format from what we are normally used to. I will not be asking the questions. I will be asking a few, but the bulk of the debate is going to be between Sri Sridhar ji and Sri Venkataraman ji. So I now request Sridhar ji to take over and start this process going. Thank you, ji.
Thank you, Sridhar ji. Namaskaram, Venkataraman ji. Happy to be engaged in this conversation with you. So let's start the discussions on the topic of CAA, which is uppermost in the minds of the people around the world, but more specifically in United States, with lots of councils passing resolutions. So give us an understanding of the objectives and the rationale that became the driver for this law.
See, first of all, citizenship is something which is a sovereign right, which every nation decides whom to be given. And India has four formats: by birth, by descent, by registration, and by naturalization. And how were we giving citizenship? Prior to 1950, whoever is born within the United India, unsplit, unpartitioned India, were granted citizenship. 50 to 87, children born out of illegal migrants were granted citizenship. 87 to 2004, children born, one of them being an illegal migrant, was still permissible. And after 2004, then it should only be through a legitimate process. So for 54 years, we have bequeathed and granted citizenship to children who are born out of illegal parents, illegal migrants. This is one form which you should register, because there is a concern that the CAA, what will happen to children? For 54 long years, we have done it. The second important capsule which one should understand is, after the Indo-Pak War in 1971, India and Bangladesh entered into a friendly treaty and agreed on three timelines. Whoever came into India prior to 1966 from Bangladesh were granted citizenship. 66 to 71, they have to go through a process and a 10-year waiting period to do it. And people who entered India thereafter, both countries agreed that they can be deported. That's the statement. That's the fact. So you are entitled to deport. So the simple question is, from 1971 to 2020, what did we do before passing this law? See, from 61 to 65, we have deported more than 1.5 lakh people into Bangladesh. Whereas in this 40 years, according to a Supreme Court judgment, we have done less than 2,000 people deported into Bangladesh. Many of them have returned back. So you must know, before this legislation is passed, what happened in the country. There was one particular enactment called IMTD Act. All of us know, if suppose you are found to be an illegal migrant, identification and proof should be from your responsibility, or it should be the responsibility of the government. The law said it shall be the responsibility of the person who is the illegal migrant. But this law was changed by the previous government. And they said for Assam alone, the responsibility will be that of the government. Only for that state, not for rest of India. And Assam received the bulk exodus. And this law stayed in India for 22 long years, from 1983 to 2005. And Supreme Court in the Sonowal first judgment records as a matter of fact. What has this done? What are the damage it has done to India? Huge pressure on border districts. Huge pressure of population into interior parts of Assam and the neighboring 6 states. The geosphere started to change. The geometric started to change. The local population started to become slowly grow less. They started to lose their control. And these people who entered into India started to occupy fertile lands, dry lands, natural resources, forest areas, minerals. And smuggling was happening 3 times more than the domestic trade in between this country. So it virtually shattered the hopes of the northeastern states because of this improper law, which took 22 years. The Supreme Court had to finally declare it as a bad law in 2005. So this is one milestone, one judgment. They upset that they wanted to get over this law again through an executive circular, and in 2007, second Sonowal came and said that is also wrong. And in 2015, Supreme Court has reframed against the issues. And what did the Supreme Court say ultimately, bottom line? The union has a responsibility under our constitution, under Article 355, to ensure there is no external aggression, there is no internal disturbance. And Supreme Court concluded in these 2 judgments, the union has failed in its job. The union government has failed in its job. And this has resulted both in internal disturbance and external aggression. Whatever I'm saying, it's all there in the Supreme Court judgments. I am not going to talk. Nothing is my points. So this has to be remedied. Is it not? Or should we not think of our citizens? Will not a country think of the interest of its own citizens? Is it wrong on the part of a government to think what is best for its citizens? When Supreme Court says you have failed in your job, the previous government. And therefore, this necessitated the passing of this law. This is the historical background.
One of the questions that often come up, thank you for the context, where what should have been a proactive approach of the government to address the issues which confronts the nation. And you beautifully highlighted the internal disturbance and external threat should have been. But the Supreme Court, in this instance, took the initiative and asked the government to come up with a resolution to this. So this is a great kind of context that you have set. One of the questions that pop up or that gets raised is the law in tune with international human rights convention as well as other legal frameworks that make up this issue?
Very good. I think, it's a very apt question. Let me take it. See, the presumption everybody will have, every listener, every reader will have is, after all, Supreme Court has declared all of them as illegal migrants. Therefore, when they are illegal migrants, why is India trying to now give citizenship and for whom? It's a genuine doubt, very, very genuine. Now comes the answer, the right question you have asked, international protocols on human rights. See, we have the United Nations Human Rights Declaration and also the subsequent human rights value 1951, 1966, 1971, several such protocols and instruments. What have they said in short? In short, they have classified such people fleeing from one country into another into 4 broad categories. Number 1, people who flee from neighboring countries because of persecution on account of religion, caste, ethnicity, etc., etc., etc. Where persecution is on account of any one of these reasons, including religion. That's one category. Category 2, people who flee because of temporary turmoil there. But on restoration of normalcy, can actually go back to their nations. That is category 2. Category 3, people who are actually a threat to the nation through which they pass through this exodus route and infiltrate into a nation, posing a security threat, posing a threat of any sort. How to deal with them? That is category 3. And the last category is people who infiltrate into another country only for their selfish benefit, selfish gains for economic exploitation and prosperity. Now, these are the 4 broad buckets in which infiltration happens. And what does the law now say? The Human Rights Declaration say, in the case of the first category, when somebody is persecuted in the name of religion or etc., and they have no way or scope to go back to their nations, give them refugee status. Don't send them back. It is an act of humanitarian value. You should protect, nurture them. When it comes to the second category, where they come here for temporary turmoil, please have them with you. But once normalcy returns, send them back. See, if this act does not regularize Tamil, Sri Lankan Tamils, because things have become normal and people are going back. Therefore, they need not be covered under the present citizenship. So, the Citizenship Act today is passed, which will pass the filters of protocols of international standards, because what has this CAA said? It has identified 6 religious communities: Hindus, Parsis, Sikhs, Buddhists, Jains, and the Christians. Historically, there is enough evidence, enough government reports in this 70 years, including IB reports, RAW reports, media reports, everything suggesting that these 6 communities have been under constant persecution and threat of persecution on account of religion, because being a minority religion in these 3 theocratic nations, Pakistan, Bangladesh, and Afghanistan, where they have embraced to Islam as their constitutional religion. So persecution became the basis, and it is in line, in sync with international standards. They were granted refugee status. And what has India done today? This government has shown the lead to the world by improving their status from refugee and granting them citizenship rights. So the first kind of a resolution in the whole world by a democratic state which says you can't go back, and protocol says don't send you back. So instead of retaining you as refugees, we will rather grant you citizenship rights. So is it an act of humanitarian value, or is it something which impedes with the humanitarian value? I leave it to you. Now, when it comes to the second, we give them refugee status, but whenever peace returns, they go back. And remember, the last 2 categories, the declaration protocols very clearly says, Article 32, if somebody is going to be a threat to your nation, there is no need for you to give any refugee status. And when it comes to economic plundering and selfish prosperity earning and infiltrating into a country for their own gains, no protocol says you should grant them refugee status. So when the last 2 categories do not even deserve a refugee status, where is the occasion or the need to grant them citizenship rights? So this is how the buckets are split, and the confirmation of citizenship is, what is this? 11 years has been reduced to 5 years, and you will have to go through the naturalization process. And a cutoff date has been given as December 31st, 2014. Only for the first category, in tune with international protocols. I hope I'm clear, Sridhar.
Absolutely, absolutely. I think you bring about a very interesting point, which is namely going back in time, when there was an exodus of refugees as part of the crisis in Sri Lanka. A lot of them came into Tamil Nadu. Of course, they spread into adjacent states, but They were refugees, and the intent was very clear to move from their disturbance, and India accommodated, and they all, out of their own volition, have gone back. Whereas in this instance, what we are referring to is,
and they were enjoying what is called the standard operating procedures governance, and they were virtually enjoying all the rights, virtually, in our country, till such time they could return back.
It's quite amazing.
Yeah.
Quite amazing. So I think it's what you're saying is that that's something that we need to that message needs to be got across, which is, there is a precedence of refugees coming in, being very well treated, and out of their own volition, when normalcy returned, they went back. And
which is not happening in these 6 communities in these 3 nations.
Right.
And therefore, there is a need to grant them citizenship rights, which you need not grant for the majority community which is infiltrating into the country for economic gains. See, Supreme Court has recorded in that Sonowal judgment, land space, forest space, border pressure, and demographic changes, huge population rise of their clan, and depletion of population of one's own citizens of that particular area. All this is recorded as a matter of fact.
Interesting. So in other words, the 2 questions that is enshrined in the Constitution, which is namely internal disturbance versus external threat, which mitigates the need for the government to grant, we are beginning to see the evidence of it in parts of the country, in terms of people occupying others' jobs, others' land, and depriving the people. It's not quantified, but anecdotal, it's evident.
It's like people entering your house and taking control of your house. And if governments and if policies are going to say, no, you should, on humanitarian grounds, allow all this to happen, will a government say, can a citizen take it? That's the question you have to ask for yourself.
Got it. So in terms of the this internal disturbance and external threats, especially the smuggling and all the stuff that's going on across specific borders and the terrorists coming in, is there a framework within the law that helps the government to enforce it?
See, good you asked this question. In fact, or else I would have volunteered to say this. See, in a democratic nation, whenever a legislation of this nature is passed, it is prone to a challenge before the court. So the present amendment is also challenged in the Supreme Court, and it is pending. That's why if you see my talks all along, wherever I have spoken on CAA so far, we have been very careful. Whatever is now being discussed, they are not interpretations of Constitution, interpretations of provisions of law. That is all something which needs to be done in the court. What has been supplied as a basic information to all of you to facilitate a proper understanding is basic facts of what has happened historically. How has Supreme Court dealt it? How has international protocols dealt it? Nothing is my own imagination. Nothing is my own interpretation. These are collation of facts which is available in public domain. Therefore, now the question is, even though this is challenged in the court of law, the Supreme Court has not stayed this law. Had it stayed, then none of us would be discussing it.
Yeah.
So because it has not been stayed, it will be heard at some point of time, whenever the court finds it fit. And our courts are guardians of our rights. And as citizens, all of us have great faith in our institutions. So whenever it comes up for hearing, it will be decided. But meanwhile, because the law has not been stayed, post-COVID, whatever has to take process as a rollout in as conceit may happen. Let's wait and watch.
Great. Thank you. In terms of the rollout, as you say, we have to wait till the COVID situation changes in India, and then, of course, how the law is, how the pending case is taken forward. So that's something that we have to kind of wait and watch. But in your view, do you see any operational challenges for India in terms of enforcing and making this work so that everybody benefits?
See, as I said, as long as this, because matter is pending in the court and court has to finally resolve it. Once we get a final resolution, then there is no impediment at all. But till such time, because it is under challenge, in the absence of a stay, you are technically entitled to enforce the law, and in strict terms. And because even when they have in the Assam Mahila Samhita Mahasangh case, where there is a reference to a larger bench challenging one of the provisions of the Citizenship Act, the court has very clearly said, we are not staying the law. We want the law to operate till such time it gets decided. So that is the situation today when it comes to legal operational mode.
Great. Wonderful. Thank you for that summary. I think that what we are also seeing is, because there is this time gap, there is a misinterpretation, which is why, or incorrect presentation of the law. There's a lot of questions that's being raised, more specifically in United States. It has gone even to the Democratic candidate for presidency, Mr. Biden, who is saying the CAA is, they will oppose CAA and take it up with the Indian government. So what should be, what's your advice to people like, him here in United States, how we engage various bodies?
Because there was a request by all of you of what is happening in the US, we thought it's our duty to narrate the facts. It's our duty to present what courts have said about it, and our duty to present what international protocols envisage, and how India has taken the initiative of converting a refugee status into a citizenship right for persecuted minorities on account of religion.
Yeah.
These are the facts which, as facts as available in public domain, we are sharing to you. Now, on assimilation of these facts, if somebody is able to formulate something, no, it is still against something else, then it will make sense and meaning to address it. Now, I did have a brief understanding of what is happening in your country. I don't see material substance emanating out of giving a justifiable reason as to how the Indian government's action in passing this law is bad. In what way? The simple question is, if following, when Supreme Court says union has a responsibility, union government, then the union government takes up a responsibility. Is it wrong? When protocol say this is what you should meet with, then that standards are met with, and standards are met with beyond that. See, if you read, we had an occasion to lead the laws of 80 countries on citizenship. India's rules on citizenship is far ahead on many of these countries. And I need to answer this from the concern, because you raised this question. It's my duty to open this concern for all of you to understand. See, look at countries like Turkey, Egypt, Syria, and through the Africa route, Libya into Italy. See the historical precedents that has happened in the past. Infiltration from these nations happen only into Europe. It doesn't happen into Middle East. Why? So they have applied caution. They have applied prudence rightly. So they don't have border infiltration as a challenge. Whereas Europe is facing this in a big time. And his statistics say in 2015, 7 countries had issues. In 16, 17 countries had issues. And in 17, 24 countries are under attack. So all of us are in a defining moment in history. See, there is nothing called global citizenship. Every country has its borders. Every country has its own citizens. And every government ruling a country will have the aspiration to nurture, protect, and serve its citizens the best way. And when you do or pass a law to ensure that is happening, is it right to find fault with? There is one concern which I'll address again. There is a misconception that this law is seeking to disentitle or disrobe the rights of some of the minority communities who are citizens of India. Not at all. Not at all. This law is not to take the citizenship rights of an existing Indian citizen. See, you must understand, all over the world, citizenship has nothing to do with religion. If you are an Indian citizen, then you are an Indian citizen, irrespective of the religion to which you belong. And if you have already acquired an Indian citizenship, this law does not take away your right, irrespective of the religion to which you belong. So, what is the challenge? Is the question. Is the doubt which we want to genuinely raise with you. And why are you therefore, maybe it is misunderstanding, maybe it's a misconception, maybe it is a planned agenda, we do not know, we are far away from. But with this fact pattern, it's for you to now apply your mind into this. Have an understanding.
Thank you. So if I just flip this question slightly differently, the way it is being articulated is, why only 6 communities? Why not all communities persecuted? Okay.
Good question. I'll answer it. It's a very good question, rather. See, there are 3 misunderstanding or misconceptions as far as this law is concerned. I had clarified one. Existing Indian citizenship will not be losing any of their rights. That's the first point I should clear. Now, 2, people who are a threat to India and people who have infiltrated into India who have not been persecuted on the name of religion. International protocols say you don't have to even give them refugee status. So they need not enjoy any citizenship rights. So they can stand excluded. They stand excluded in this law. Therefore, it is in line with the benchmarks set by the international protocols. Now, the case which you are trying to project is amongst the Muslims. You have the Rohingyas, the Ahmadiyas, and the Shias, who are minority Muslims and who can be persecuted, and therefore, why not India regularize or grant citizenship for them? If I've understood your question.
That's correct.
Yes. The answer is very straight and simple. None of the 3 belong to the Indian origin. Shias belong to Iraq, Yemen, and Indonesia. And when it comes to Rohingyas, they belong to Burma. And when it comes to Ahmadiyas, they are Turkish Muslims, Mongol origin, Uzbek native, settled in Punjab province in Pakistan. This is the first understanding you should have. And the second important understanding is, as far as Rohingyas is concerned, even Burma and Bangladesh consider them as a serious threat. So when somebody is a threat to your nation, protocols do not allow you to even give you refugee status.
Yep.
So there is no need to give a citizenship. As far as Shias and Ahmadiyas are concerned, they have their own challenges in India because India is a Sunni-dominated Muslim population. So these people don't even come for SOP. They are not compliant even under the standard operating procedures. They will fear to identify themselves. So we are talking an illusory problem. To say you should have regulated, you ought to have regulated. And when somebody is not of an Indian origin, where is the need and a requirement to grant him citizenship? Whereas the 6 persecuted communities, which is governed, you check for yourself, have ultimately, they have all been people who have lived in this place in the unified India. And why did they also extend the policy to Afghanistan? They found out, as a matter of fact, that people of these communities living there have also been persecuted, and therefore they cannot be left alone. This is the policy logic of bringing this law.
Great, great. Thank you for the clarification. This Rohingyas issue is, like sitting in the periphery, because vast number of them came from Myanmar, and the CAA law is around the three countries, which is namely Pakistan, Afghanistan, and Bangladesh. So does the provisions of the CAA factor in these illegal Rohingyas coming from Myanmar rather than Bangladesh or Pakistan?
See, as I said, we need not have to factor them even in terms of international protocols for a refugee status, because if somebody is found to be a threat to you, a threat to your nation, that is a good ground for you. Article 32 very clearly says you don't have to give them even refugee status.
Yes.
So why should India be giving them a citizenship right? Is the question an answer for that question?
Got it. Thank you. So if I, here we like summarization and sound bites. So if I have to summarize, and then I'll hand it to you for your observations, and then we'll hand it to Mr. Sri Iyer. If I have to say, the law is clear in terms of a specific set of issues that India confronts by virtue of people illegally occupying the land and economically creating a deep malice to the people.
Correct.
Second, they potentially are causing internal disturbance, as well as there's evidence of external threats resulting smuggling, terrorists, etc. Okay, the second. The third, in the framing of the law, India has gone well and above beyond the call of duty in terms of being humane in recognizing a number of people who otherwise would have been refugees have been given citizenship. It chose specific provisions so that certain persecuted minorities are protected. So even by human rights convention and protocols, it's well and above beyond anything that's existing today on that point.
Okay.
On the third message that we kind of take away is that this has been tested and ratified, and by Supreme Court, there is one outstanding issue that's still pending. So there is a framework with which the government can enforce this until such time there is whatever the resolution is. The fourth is that it requires people like us, hearing from you, experts, to disseminate this information in a very open and transparent manner so we can at least enlighten the people of what the truth is rather than what the perception is. And it has also factored in the question that there is no internal threat for existing citizens of specific communities, and the exclusion of certain communities is within the framework of the law and the refugee and other criteria. So that's our kind of takeaway as we kind of hear from you.
Yeah, except for one small change. See, Supreme Court has not ratified this particular law. This law is under challenge and it is pending.
Yeah.
What Supreme Court has done in the earlier 3 occasions is, when they tested a law which was supposed to identify illegal migrants and deport, did not do that and could not do that. It, on the converse, prevented the Union of India in implementing and ensuring deportation. That law, which stayed for 22 years, which permitted mass exodus and infiltration, giving rise to the present problem, was declared by the Supreme Court as a bad law. But it took 22 years, and much water flew under the bridge before that. And Supreme Court in 2015 is therefore asking a question. In 30 years' time, when you have signed the Assam Accord promising that the illegal migrants will be deported, in 30 years you have identified some 31,000 cases, 10,000 cases of illegal migrants, and 2,000 have been. This is all you could do. When the exodus is in crores, because of a law which was draconic, that law was held to be bad. And while holding it to be bad, it held that union government has failed its duty under Article 355. Therefore, that it became an obligation of the union government to ensure that it protects in some way the threat of internal disturbance and external pressure. Yeah.
Got it.
This is the reason, the basis. And when they passed it, the criteria meets with international protocols. And it is not classified on the basis of religion. See, the misconception, the popular misconception is India has taken selected religions and left out selected religions. And therefore, it is very, very arbitrary. One religion is taken, another religion is left out. No, it's not so. It is classified not on the basis of religion. It is classified on the persecution caused to people who belong to a religion. Those religion which are persecuted and those religion which are not persecuted. So the basis is persecution, not religion. That's one misconception many have.
It's a very important distinction in articulating the Amendment Act, which is around the fundamental thesis is persecution and who have no remedial mechanisms where they are.
It's not mere persecution. Persecution in the name of religion. Therefore, yes, it is the persecution that became the basis. So if A is persecuted and B is not persecuted, if you grant a liberty to A and do not grant a liberty to B, how is it wrong? Is the question which needs to be resolved.
Great. Thank you so much. And if you have any closing comments, then you can make your comments, and then we'll hand it to Mr. Sri Iyer for questions from the public.
Yes. It's, as Indian Americans, it is my request that whatever has been stated in this last 30-35 minutes are all evidenced through judgments and protocols and government reports. All of them are available in public domain. I have not tried to interpret law, or I have not tried to nuance something, invent something, nothing of that sort, because the rights and the legalities are pending before the court. Court has to do the job ultimately, and all of us have to pursue the court. That's a different. But facts as happened can always be shared. So that's exactly the job which we have done now to you. For your understanding, for children to understand, for women to understand, so that when somebody confronts you on facts, you can say that, please see the basis. This is more an idea to make you aware, because you are simply taken aback. Something is happening in your country, either with your knowledge or without your knowledge, and you don't know, you're becoming clueless. So it's for you to make you understand these are facts. Anybody can go and read it. It is available. Have that conviction. Indian government has not committed a mistake. You should first have that self-conviction. That's very important. And the whole purpose is only to share that information to all of you.
Thank you. Thank you.
It was are you a lawyer? You're not a lawyer, no?
No, I'm not a banker.
Oh, you're a banker. Very, very happy that
I count money.
You count money before winning. We count money either winning or losing. Thank you so much. It was a pleasure. Thanks, Sri, for this opportunity to speak. I'm ready to take questions.
So that was a very engaging, erudite conversation that we saw, viewers. And the clarity of thought and expression comes through very clear in Sri Venkataraman's ideas, and very good questions from Sridharji. And I think the intellectual level of this discussion is something that has to be seen to be experienced. And it is my hope that the remaining 30 odd city councils that are mulling over passing a similar resolution can spare these 30 odd minutes to look at the rationale behind why this law was passed. And I'm going to do my very best to make sure that all these city councils are made aware of this video, that they can take a look at it. This is something that they have to look at it at the very minimum to try and pass a resolution, because it is very unfortunate that in some cities, quoting coronavirus, the other side was not even given a chance to state their side of the story, and the resolution was passed. So let us hope that the remaining city councils who are looking at this will apply their mind a little bit more effectively. And then let's hope that, at the end of the day, we all know Satyameva Jayate, truth prevails. So with that, sir, thank you very much to Venkataraman and Sridhar. And I'm going to give take a few questions that our viewers have been sending us. So the first question is from Mr. Muthu Kumaran. This is about illegals from Bangladesh. What if Bangladesh does not accept them and India has to bear with them? In such a case, should India seize some of the Bangladeshi territory near the Chicken's Neck and the Myanmar border?
See, I don't want to be answering this question as a law officer of a country. So, see, I think, this. Please take it as a personal answer. I have never believed in hurt, hate, and humiliate. It doesn't work. We have a job on hand, and we have passed a law. And once this law is decided and rights gets finalized, then whatever is the consequences that needs to follow has to follow. It's as simple as that.
Thank you so much, sir. That was an answer given in his personal capacity. I think I want to take cognizance of that. The next question is from Vaibhav Tanwar. Sir, do you think the bar for citizenship should be raised higher? I think government is being soft on setting standards. This is again his personal observation.
See, these are all policy matters. Lot of thinking goes into it. And it's easy to sit and say this should be done, that should be done. The idea is whether what has been done is right. That should be the test.
The next question is from Sachin Sharma. Why hasn't government debunked the theory of linking CAA with NRC, which eventually led to people thinking that even when NRC is not drafted, but somehow that is going to be applied to the entire country?
See, it's a very interesting fact observation as we see it from the various government reports. Every government at some point of time, whether as a single party rule or as a coalition, throughout India's governance, at some point of time, have spoken about a population register and an NRC. It's not as though it's all coming up suddenly in 2019. Do not think so. It has always been there in the agenda. And see, CAA is a law. It decides the policy choice. NRC is a procedure. And the assumption, suppose you don't have an Aadhaar card, tomorrow you will be sent to a detinue camp. It's all. See, this is the way rumors spread hard. You will have choices, multiple choices to show your identity. So this is a process which coalesces with the law. And the process has to go. See, procedures can always be adapted to suit contingencies, needs, and emergencies. Policy choice is something very paramount. Decide the policy choice, procedure will fall into place. Don't worry about it.
Thank you very much, sir. This is the last question of the day. Lokesh wants to know, do we anticipate any more trouble like Shaheen Bagh again in the near future? I don't know how you can answer that question, but somebody asked that question.
In democracy, we are all evolving each day. It's a is an experience. So nobody knows what is in store. Did we anticipate COVID? And did we anticipate 162 countries going for a lockdown? We don't know what is in store for future. But India is a country, a democratic nation, where respect to rule of law is there, and courts as guardians of justice protects the interest of the citizens. So we have all the three organs which are quite vibrant: the legislature, the executive, and the judiciary. And it's a solid democratic nation. And therefore, whatever may be the contingency, whatever happens, India is capable of handling them. That assurance is something which we can convey to Indo-Americans.
Thank you once again, Venkataraman ji, Sridhar ji. I can't express in words this session that I've just hosted, because it was a pure intellectual discourse, and it goes to the very soul of the matter. Why CAA? And I think you've answered all the questions, all the doubts that were lingering in people's minds. And it is my belief that after seeing this video, whoever is trying to make a decision, be it a child going to high school in the United States or any other country in the world outside of India, or somebody going to college, or somebody working and having a water cooler conversation or a lunch conversation, if they see this video, and I hope the viewers will forward the link of this video to all those people who are having questions, because this clarifies, in my opinion, in the most thorough manner, all the different considerations that went into passing this law. I'm sorry to take so much time to just wrap this up, because it is important to recognize that this particular video is going to go far, and I think we have crossed a line here, in the sense that we have now said this is what the government thought when they came up with this law, and it is up to you to make your own decision, come to your own critical apply your own critical thinking, and then decide what it is that you want to do. Thank you once again. Thank you very much. Namaskar.
Namaskar.
Thank you, Sridhar. Thank you so much.